In this country, the executive, the legislature, and the judiciary form the nexus of power. The judiciary is usually the most independent as the supreme seat of the law. The Chief Justice, as head of the judiciary, has the ultimate responsibility for the administration of the courts and the legal system. But over the years, our legal system has been wrought with issues, outdated procedures, and an overwhelming backlog that carries over year to year. In the past few months, though, the sitting Chief Justice has undertaken an aggressive reform and modernization program. Every new season of On the Record, we push the limits, venture into unknown territory, take our cameras into places unseen before. We share the stories and experiences that affect us all. And now it's time for Season 5. On the Record, Thursdays at 8 p.m. on RTV, cable channel 212, and streaming live on Facebook. Hello and welcome to this edition of On the Record. I'm your host, Jerome Sawyer. We are on location today at the Balmoral Club. The position of Chief Justice is authorized by Article 93.2 of the Constitution of the Bahamas. Under Article 94.1, the Governor-General appoints the Chief Justice on the recommendation of the Prime Minister after consultation with the Leader of the Opposition. Now, his primary functions are to preside over the Supreme Court in its public sessions when the court is hearing arguments and during private conferences when it is discussing and deciding cases. Having said all of that, I guess you can figure out by now who my guest is for the special edition of the show. Chief Justice Sir Brian Moree. Sir, welcome to On the Record, and thank you for agreeing to this interview.
Thank you very much, Mr. Sawyer. It's good to be with you.
So we have a lot to talk about in this period of time, but I'm going to start with, I think, what's the most important, and that is the effect of the COVID-19 pandemic on the proceedings of the court. Shortly after the opening of the legal year in 2020, we would have begun experiencing this pandemic and the entire country shut down, inclusive of the court and the operations. How have you been able to navigate through these times, and where are we now in terms of the reopening of the court system?
Well, it has been a very difficult and challenging time, but the first point I would like to make is this. The courts in the Bahamas never closed. I have heard persons state that the courts closed for a while. That never happened. We have a constitutional obligation to remain open even during times of war and emergency. And while the operations of the court were scaled back, and we suspended certain activities in the courts themselves never closed, and the Bahamian people need to know that. Throughout the entire period of the public emergency, dating back to March, I think it's the 17th of 2020, we have always heard bail applications. We have always dealt with arraignments, which are first pleas by persons who are charged by the police. We were always dealing with urgent applications on the family side, domestic violence, issues concerning children. So that's the first point I would wish to make. Now, how have we navigated through all of this? There was a period of time when, apart from emergency applications and constitutional applications, hearings were suspended. And that was a time shortly after the declaration of the emergency in March. It wasn't many months after that we began to pivot to a remote platform, like courts all over the world. It was difficult for us because we did not have a technology platform in place throughout the judiciary. We had very little technology available to us. So we didn't have the head start that many courts had around the region. I was just building up our technology platform, trying to create some institutional capacity. So that was particularly challenging, but we were able to start certainly on the non-criminal side. That's the civil side, the commercial side, the family side, landlord and tenant, and I'm talking about the Supreme Court now.
Mm-hmm.
So we migrated to a widespread use of Zoom and WebEx, and we began to conduct remote hearings. And over a period of several months, we actually migrated to the restoration of 80% of our court applications, most of which were being done by remote. So the Supreme Court on the non-criminal side was the first side of the court to recover and to resume most of its operations. It wasn't long after that we actually began to do trials remotely. We did some in-person trials, but we figured that out. And we are indeed still using our remote platform for trials today. So on the Supreme Court, an initial scaling back, a migration to our technology platform, a wide integrated use of Zoom and WebEx. I must say that the bar was very cooperative in this regard, and the lawyers responded very well. And then we gradually resumed our operations, whereas today, on the Supreme Court, on the non-criminal side, we are 100% back with full resumption of operations. Now, let's just quickly say on the criminal side, it's much more difficult to use the remote platform because both the legislative requirements and the constitutional requirements limit us. So our criminal trials have to be in person because we have jurors, and it's very difficult. There are some jurisdictions which are using remote platforms for jury trials, but we're not doing that, and very few courts in the region are doing that. I'm happy to say that we have resumed hearing criminal trials in person. The volume of those trials now we're trying to scale up. We started with a limited number, and we are increasingly and incrementally increasing our trials. The Magistrates Court has been a much more difficult place because it's hard to use a remote platform in the Magistrates Court because of the volume of work and the nature of that work. So I'm happy to say that while we had suspended trials for a long time, we have now resumed criminal trials, civil trials, trials on the family side, and we're gearing up. We're waiting for some of our courts to be retrofitted with plexiglass, which is the key for us to get back in the courtroom. Mm-hmm. So today, we are, I would say, across the board, probably 70% back to full operations, and I hope within the next few months that'll be 100%.
In your remarks during the opening of the legal year, you said, "We defy the pessimists by making significant progress in many areas as we remained laser focused on court reform and modernization." I think you would have spoken to some of that in your previous comments there, but what was done specifically to reform and modernize the courts? I mean, by your opening remarks, you mentioned that we were behind many of the courts in the region. But if you could speak to what kinds of things you did to reform and modernize.
Well, we have a project which I launched called the Court Modernization and Reform Initiative. Mm-hmm. The acronym is COMRIN. And it comprises 14 or 15 different components. Let me just give you a quick review of some of them. First of all, we have a listing office, which is the gateway into the court system. This is the office which gives out hearing dates on the non-criminal side. This office was 100% manual. We have now completely automated the listing office, and now dates are being given out on the basis of online forms on our website. So that process is being cleaned up, it's been rationalized, it's much more efficient. Lawyers are now getting hearing dates through emails, don't have to come walking into the office, don't have to go knocking on judges' doors. So we've automated the listing office. Second point, as surprising as it may sound, we in the Bahamas do not have a case management system throughout our court system. This is a system which allows the court to manage all of its cases. The case management system is a platform which allows you to introduce e-services. It allows you to track cases. It allows you to know when cases come in, what stage they're at. It allows you to offer a whole range of e-services, e-filing, e-scheduling, e-calendaring, e-probate. This is a significant move. We have now signed a contract with a vendor to provide an integrated case management system to the courts, which is going to fundamentally transform how we manage cases. That's the second point. The third point, we have signed another contract with a vendor for the digitization of all court records. This is a very big point because paper is a problem. Files get lost, files get misplaced. You got to remember, Mr. Sawyer, we are operating out of 7 different buildings, our court system in Nassau. This is very difficult. This is not efficient. It's not the way to do it, but that's where we are. So the movement of files is proven to be very difficult. And the reason why this is so important is it creates a lot of adjournments because the files cannot be found, the paper isn't where it should be. So the digitization project is a big one, and we're going to be moving away from paper, and we're going now to digitizing all our court records. That's the third initiative. Fourth initiative, we are relaunching what's called the digital recording system, where we're going to have in every courtroom a digital recording system which will record the proceedings. We'll be using this in conjunction with our court reporters, but it will make us much more productive. We'll be able to produce transcripts much quicker. It'll expedite appeals, and it will, to a very large extent, mitigate the shortages that we have with court reporters. So the digital court recording system is a big part of our reforms. We've also introduced a bail management system, which has totally automated the process of applying for bail. Much more efficient. We had a soft launch in December, late November. We're moving towards a hard launch of that bail management system, I hope within the next 30, maybe 45 days. I could go on.
Yeah, well, I've got to ask, though, I listen to these things, and modernization is always very important. We live in a time where everything is becoming digital. But to the average person, what does this mean for the administration of justice? What does this mean for me when I have a case before the court, or if I'm charged, or if there's a matter that I'm involved with, whether I'm the, whether I'm the victim, I'm the defendant, I'm the lawyer, what does this all mean for Bahamians?
Well, let's try and answer that directly. First of all, significant increased productivity in the court system. What does this mean for the average person? It means that your cases are going to be heard more quickly. What I call the disposition cycle, that means the time period from when a case is started to when it's concluded, right? That disposition cycle, right, is far too long across the court system, and this will allow us to reduce the disposition cycle. It is going to mean for the average litigant, whether it be in the magistrate's court or in the Supreme Court, far more efficient service. It's going to reduce the costs, I hope, because of the nature of these reforms. For instance, instead of lawyers coming down to court for every hearing, they're going to be able to sit in their office and do it by remote. That's got to reduce the time period. Most lawyers charge on a time basis or a flat fee basis. So it's going to make the courts more productive. It's going to reduce the period of time for the average case to be dealt with. I hope it's going to reduce the costs of litigation with regard to the cases that are commenced. And thirdly, it is going to be much more convenient for litigants, where they are not going to have to come running down to court every time there's an application. For some litigants, this means taking time off work, which of course has a financial impact. They're not going to have to do that now, right? Because we're doing so many of these things by remote. So bottom line, and that is, if I may say respectfully, that is really a good question, because that's the ultimate test as to whether all of this is worth it. How does it affect the average court user?
Because, sir, I'll tell you, one of the greatest criticisms of the court is the delay, the time it takes to dispose of a matter, the backlog that we keep hearing about of cases. I mean, from the time I was a young reporter, we go to the opening of the legal year, and the one thing we're listening for is for how many cases were disposed of, what's the backlog. But and I think it ties into this, the justice delayed, justice denied. So will this move these cases along faster? Will the Bahamian public be able to feel like they are getting results from the courts and it's not this situation where cases are dragging out for years and years?
The simple answer is yes. If it doesn't, then the initiative has failed. It is specifically designed to reduce delays. It is specifically designed to expedite the way cases are dealt with in the court system. Now, I would just give this word of caution. Mm-hmm. We're trying to do something which is really very large. Reforming a court system is not an easy thing to do, and it will take some time. We got two major hits, like the entire country did, with Hurricane Dorian and with COVID-19. That has substantially reduced the resources that are available to us, although we've worked with the executive branch to try and get as many resources as we can. So I would just urge some patience on behalf of the Bahamian public, but absolutely definitively, the impact should be felt by the Bahamian public. Criminal cases are going to be dealt with more quickly. Civil cases, the disposition cycle, I hope, can be reduced at least by a third. I mean, we have targets for what we call clearance of these cases. So I hope the public is going to find, first of all, the courts are more user-friendly. We're working hard on what I call the service platform for the courts. Our front office has to be sensitized and trained, I think, a little better to deal with the public in terms of their interaction. We're going to have less of these adjournments. Judges are going to be, and magistrates are going to be more focused on disposition. The delays, I think, will be reduced. I cannot say they will be eliminated, mm-hmm. because inherently there is some delay in the way in which court systems work. But yes, it should bring down the cost of litigation. It should reduce the time on both the criminal and non-criminal side. We should improve the user experience through our service platform. And of course, with smart use of technology, we hope it'll be much more convenient for the public to access justice.
Chief Justice, we're going to take our first break in the show. We've got lots more to talk about. Stay with us. This edition of On the Record will continue right after this. Every new season of On the Record, we push the limits, venture into unknown territory, take our cameras into places unseen before. We share the stories and experiences that affect us all. And now it's time for Season 5. On the Record, Thursdays at 8 p.m. on RTV, cable channel 212, and streaming live on Facebook. Welcome back to this edition of On the Record. I'm honored to have as my guest the Chief Justice of the Commonwealth of the Bahamas, Sir Brian Moree. Sir, in our first segment, you mentioned the bail management system with the soft launch taking place in December of 2020. I'd like to talk a little bit more about that and what will that mean for expediting cases?
Well, this is going to allow the process of granting bail or applying for bail to be fully automated. So it's going to substantially reduce the waiting time to have your application heard. It's also going to greatly facilitate the signing in conditions that are often applied to bail. Many times when bail is granted, it's on the condition that the accused person has to sign in at a certain police station once a day or twice a day. What's going to happen now is we're going to have kiosks in, I think it's 5 or 6 of the largest police stations in Nassau, in New Providence, and I think 2 or 3 police stations in Grand Bahama. So accused persons, as opposed to having to come into court or go into a police station and sign something manually, they're going to be able to go into a police station with a kiosk. They're going to be able to use their fingerprints. The whole process should take about 2 minutes, and they'll be able to fulfill their reporting requirement. They won't have to have any real interaction with police officers. They won't have to wait, and they'll be able to sign in and then leave. This is going to be far more convenient, far more effective, because it's going to allow us to monitor the signing. And right now, there are times when a judge may not know that the reporting requirements are being complied with for 3 or 4 weeks. It just takes that amount of time for the manual procedure to get back to the court. Now, a judge will be able to go literally on his computer or iPad, and he will be able to check exactly when the person signed in. He'll be able to monitor that, docket it. If there's any issues, he'll be able, of course, to respond very quickly. As far as lawyers are concerned, it's going to be much more convenient because they're going to be able to do this largely online. It's going to allow us to monitor, to track. It's going to be more convenient. It's going to save time, and it'll greatly reduce the bureaucracy that is now surrounding the whole process of managing the bail system and of complying with these reporting requirements.
One of the other issues that plague a lot of people that have to do with the courts that you would have mentioned during the opening of the legal year is the introduction of the court automated payment system in the family court of the magistrates court. If you can take us through that and what that will mean for the individuals who must pay or receive payments based on a court judgment.
We think this is a really important initiative. Right now, when the magistrate makes an order for, say, John Brown to make a payment of $150 a week, to Mary Smith, what has to happen now is that John Brown has to come into court. That of and by itself is very time consuming. There's a lot of people. We only have 1 or 2 cashiers, so that whole process can take a lot of time. They have to physically pay the money. It then has to be logged. It has to be put into it's virtually a manual system. There is I think they use a piece of shelf software, which is really not very good. And then the receiving party then has to come every week to collect this money. Now, a little while ago, that whole process has caused many, many problems. Very frustrating for the public, both the paying party and the receiving party.
They complain about it constantly.
A lot of complaints in the magistrates court about it. The amount of time it takes. The paying party sometimes has paid the money. The receiving party has a copy of the receipt. And the receiving party goes to the court to collect the money and is told, "Oh, we don't have the money yet," right? Because the record keeping is falling behind because it's basically manual. So all of that will fundamentally change under what's called CAPS. That's the name that we're using. That's a court automated payment system. Now what's going to happen is the paying party will be able to pay anywhere using a mobile device. A cell phone, an iPad, a laptop. They will be able to make the payments, and the receiving party, right, will be able to get access to that money in 1 of 2 ways. There are going to be a number of outlets where the receiving party will be able to go in and actually get cash if they want cash. Supermarkets, pharmacies, retail stores. There's going to be a network of these outlets, so getting to these places will be much more convenient than going to the court in Nassau Street. They'll also, instead of getting the cash, they'll be able to use digital currency actually to buy goods if they wish to do that. Bearing in mind now that all of this is done on a mobile device. So this is going to fundamentally change the way in which money is paid and the way in which money is received. This is going to be done now without any necessity to come into the magistrate's court. People will be able to do this at home, in their car. They can do it anywhere they want to. They'll be able to access their money at these designated outlets. They'll be able to use digital currency if they want to actually buy groceries and clothing in certain retail outlets. And also, the other benefit for us is that we now will have much better record keeping because the actual software itself maintains all these records. So the minute the money is paid, an email gets automatically sent to the receiving party to say this money has been paid. And then that receiving party can decide when they want to go and collect that money at their convenience. It allows the court records to be real time, because the minute the money is paid, the backside of this application does all the record keeping. If people want to know, am I in arrears? How much money do I owe? How long do I have to pay this money for? In terms of the age of the child, if it's maintenance, all of that is going to be cleaned up, is going to be far more efficient, and people are going to be able to pay money and get their money in the family court, in the magistrate's court, without having to step into the magistrate's building.
Next up, I want us to focus now on this court services bill. Something again that's new, I think, to this jurisdiction. But what is the intent of the court services bill?
Simply put, it is to strengthen and deepen the institutional independence of the judiciary, where the courts will have a higher level of autonomy over their financial affairs, over their operational affairs, and over their administrative affairs. So the courts will not have to go cap in hand to the executive branch in order to manage its budget. This is an extremely important point, because the independence of the judiciary is one of the paramount constitutional principles which really supports the rule of law and our democracy. Now, frankly, it has been said in many jurisdictions that as long as the courts have no real control over their financial and operational affairs, there's only so far that they can be independent, all right? Because they can't really decide on staffing issues, on resources issues. I mean, for instance, for me to get laptops is an unbelievably complicated process. There is no reason why the courts shouldn't be able to manage its own budget and decide how to spend its own funds. Now, I make an important point here. It is still necessary under the Court Services Bill for Parliament to allocate the funds to the court. That is a very important principle. That has to be a part of the national budget. So the courts don't decide how much money they're going to get. Right? That is a process which goes through the Ministry of Finance, and that is part of the national budget. But once the allocation is made and Parliament has approved it, then the management of that budget, how that money is spent, what it is spent, how we manage the resources of the court, will be vested in a council which is created by the statute, which will be responsible for managing the courts. So the level of influence by the executive branch over the actual management and operations of the court will be substantially reduced.
How does that then, though, affect, I guess, in some ways, still the running? Are the people who work in the court still going to be regarded as civil servants? Is that set apart separately? And you're managing your own funds, correct? So you decide where these monies will go.
Yes, the statutory model is based upon the Public Hospital Authority, which is a statutory creature at the moment, and also the Civil Aviation Authority. So there's ample precedent for this. Okay. To answer your question specifically, under the bill, everyone who is currently working in the court system, if that bill is passed, will continue to work in the court system for a period, I think it's 12 months. That was floating, it was 24 months, and then I think it was 12 months. And during that period of time, each employee civil servant will have an option to decide whether they want to come over to the council, in which case they will be out of the civil service, or whether they want to stay in the civil service. If they stay in the civil service, and that's their option, then they will be transferred to another department within government and they will stay there. If they decide to come over to the council, they have to come over with tenure, with all their benefits in place, doesn't affect their pension, right? So everything is brought over as if they continued, but at that point they would be out of the civil service and they would then be subject to the authority of this council, which is created by the statute. Mm-hmm. Important to note, it's the decision of the individual employee, and if they come over to council, they don't lose any benefits or any tenure or any pension. The idea is, over the period of time, the persons working within the court system would not be civil servants, and they would be working in the courts with the council, and that would give the council control over the resources, the human resources, in terms of hiring, salaries, if any disciplinary action is required.
We've got to go to a break, but do you feel that this will really give you true autonomy? Because what you're describing to me in some cases is, you don't want to bite the hand that feeds you, if I can use that. You're being financed by the you're receiving your monies from the executive, but when you need a laptop, when you need this, you have to go back to the executive to ask. So do you feel then that this will give you that level of autonomy that you need?
Mr. Sawyer, this bill, in my view, is transformative. It is truly transformative. It's not only important, it will fundamentally transform the way in which the courts operate. It'll give the courts higher levels of autonomy, which will allow it to become more efficient and to manage its own affairs. So the answer is yes. The bill is the byproduct of compromise, as all legislation is. Mm-hmm. But under this bill, once the allocation is made, then the courts will have complete control over how that money is spent. Now, this is not any sort of grab for power. Let me make this very clear. Right? This is not the point at all. This is simply to give the judiciary, which I might say is a co-equal branch of government. I think it's very important for your viewers to get this fact. Under our Constitution, there are three branches of government. There is the executive, the legislature, and the judiciary. Now, why is this important? That's because many people seem to think that the courts is like a government ministry.
That's how some people see it.
It's a government department,
mm-hmm.
right? Fundamentally, constitutionally wrong. Even today, without the bill, the judiciary is an independent branch of government. It's not a department, it's not an agency of the government, it's not a ministry of the government, it is an independent branch of government, which, by the way, constitutionally is co-equal. Now, I must say, in real terms, that has limited application because, as I say at the moment, the courts have very little control over its internal operations and its management of its resources. But that's really what we're trying to achieve here. So this is not to grab power. This is to ensure that the courts of the country, which, by the way, are the ultimate guardians of the civil rights and liberties of all persons within this jurisdiction, it is super important to ensure that there is effective and meaningful institutional independence of the courts, where they are not politicized, they're not subject to any outside influences, and they have control over their own affairs. So will this bill achieve that? In my view, it will. And let me say this, the bill has been carefully calibrated to ensure that the constitutional role of the Minister of Finance is preserved, that the constitutional role of Parliament is reserved, and that, as I say, the amount of money which comes to the court is still a matter for Parliament. And that's important because that's constitutionally required. Mm-hmm. But once you allocate the money, the point is, don't micromanage the courts. Right? Don't tell the courts, if I want to hire this person, I have to go through all sorts of bureaucracy. I've got to go through the Office of the Attorney General. I've got to go through the Ministry of Public Service. All of this. It can take, literally, it can take months and months to hire one person. Wow. We have requisitions to purchase essential equipment for the courts. I'm talking about things like printers. I mean, this is low-level stuff. Printers, computers, we need to improve the bandwidth in our courtrooms because now we're relying so heavily on remote hearings. All of these things, it takes me months to achieve these things. One last point, if I may. Take something as fundamental as plexiglass. Every court in the world, right, because of COVID-19, realizes that if they're going to get back in the courtroom, you have to have plexiglass barriers. Mr. Sawyer, we have plexiglass barriers in most of our Supreme Courts now, after many months. Since September of last year, I've been trying to get plexiglass in the Magistrates Court, right? And we just got the funding several weeks ago, and we're now, I think we have 4 of our courts with plexiglass, and we have I think 8 more to go. Wow. Now, all I'm saying is this: I'm not criticizing the executive, not at all. These are very difficult financial times. There is limited cash available, and these are austere times for the country. I understand that, and I respect that. All I'm saying is, if the courts had some control of the money that is available to us, right, the courts can decide plexiglass is a high priority item, right? We should be able to install plexiglass in our courts within 3 or 4 weeks. Right? We haven't been able to do it, not because of anybody's fault. I must say the executive has been very supportive. The Attorney General has been supportive. The Minister of Finance and the Minister of State for Finance have been very supportive. It's just a byproduct of a huge bureaucracy.
Understood. Sir, we've got to take a break in the show. We've got more to talk about. Stay with us. This special edition of On the Record will continue right after this. Every new season of On the Record, we push the limits, venture into unknown territory, take our cameras into places unseen before. We share the stories and experiences that affect us all. And now it's time for Season 5. On the Record, Thursdays at 8 p.m. on RTV, cable channel 212, and streaming live on Facebook. This is On the Record. I'm your host, Jerome Sawyer, and to our final segment, we're talking to the Chief Justice of the Commonwealth of the Bahamas, Sir Brian Moree. Sir, as we went into the break, we were talking extensively about the anticipated court services bill, and I use the word anticipated. It really, in your words, will be transformative if it comes to pass. Do you expect it to happen within this legislative period?
Well, Mr. Sawyer, I can only express my hope. I would hope that Parliament will have time to consider the bill and to debate it and to pass it before the beginning of the new financial year, which is on the 1st of July of 2021. The bill was tabled in Parliament. It does have financial implications, and so it would make perfect sense to have it enacted into law prior to the next financial year. So I would ask respectfully Parliament to consider that, and I hope that it can be dealt with, and if deemed appropriate, to pass it, so we can actually implement it as of the beginning of the new financial year.
Well, I do know quite a few of the parliamentarians watch the show, so hopefully they will hear that. So as we're talking money, one of the big capital projects has to do with or proposed projects has to do with the new Supreme Court complex, site of the former post office that now has been demolished. Tell us, what do you anticipate this new complex to do for the administration of justice?
Well, it again will fundamentally change the way the courts operate, because it'll take us from a position where, as I said earlier, we're operating out of 7 different buildings in Nassau, spread from George Street down to a little west of East Street. And it'll put us under one building, which of course will be specially designed and customized for the use of courts. That will, of and by itself, create enormous efficiencies, which we don't currently have. Secondly, all of the buildings which the court's operating out of, with the possible exception of 1 or 2, are basically retrofitted offices. These buildings were not initially designed for courts. And so what's happened is it has evolved over a period of time. The actual design and layout and flow of a court building is a specialized trade. It's like building an airport, right, or a hotel. These are specialized skills within the architectural profession. We would have our registry in the same building as our courts. That of and by itself creates many, many efficiencies. Right now, files have to move from George Street to Bank Lane. Right now, that is what, I don't know, 6 or 7 blocks. It might as well be 100 miles, frankly, right? Because that journey, a lot happens on that journey in terms of misplacing files, getting files in the right place at the right time. Again,
we hear it all the time. The files did not arrive to court on time.
Exactly. I mean, not any criticism of our people, because everybody's working very hard. It's just a byproduct of the fact that we're spread out all over the place. So it'll put us under one building. It'll give us a customized building, which will be well suited for courts. It'll allow us to operate more efficiently within the context of the courts themselves. The judges will all be in a single building all together. Right now we have judges, we have the magistrates in one building in Nassau Street, and we have judges in 4 buildings in Bank Lane. That really doesn't help the collegiality and the exchange of ideas and so forth.
Sure.
It'll improve our customer service. It'll improve the whole process of managing accused persons coming from BDOCs to court for hearings. That whole process now is quite complicated, actually.
I know. I've been a part of it. I having to cover court over the years. The complications. I want to move forward to one of the greatest criticisms that the public has, and I know one of the issues that Chief Justices prior to yourself have addressed, and even the Attorney General's office, is this issue of backlogs, cases that are traversed from one period to the next. One of the remedies, and something that you've mentioned, even defense attorneys have talked about, is putting greater emphasis on plea bargaining. Should that happen, first of all, if you can take us to sort of how that will work, and why do you think that will affect the backlog?
Well, plea bargaining is, in my view, an integral part of any criminal justice system. So that's the first point. There is no court in the world, Mr. Sawyer, that has the resources to take every criminal case to trial. It cannot happen. In fact, if one looked at the empirical data around the region, and particularly in North America, you will find, as I found, that between 80 and 85% of cases which are started, criminal cases which are started in some courts, are actually plea bargained. In other words, they're only taking 15 or 20% of their cases to trial. Regionally, that number is probably a little lower. It may be around 60%, 65%. So the first point is, plea bargaining is a legitimate part of any court system in order to manage volume. Secondly, I think we should expand it as much as possible. I've encouraged a greater use of plea bargaining since I assumed office. The way it works is that this is primarily an issue for the Director of Public Prosecutions and for the defense. It's not something which the court can do. At some point, the plea bargain, if it's struck, has to come to the court. And certainly if it involves sentencing a person, that would have to be approved by the judge. But what cases are plea bargained, and the active process of plea bargaining does not happen within the courts. That happens within the office of the DPP and with the defense bar. So in a particular case, the defense lawyer will get together with the prosecutor, right, and they will discuss it. The DPP would have to sign off on the plea deal, and then that is brought to the court. Judges can encourage it, which I think we are doing more and more. The effect of it is that it simply reduces the number of cases that you have to take to trial. What I've said before as a metaphor, it's like being on a highway, Mr. Sawyer. When you start the case, you get on the highway, and you go from where you start to your destination. What you need is some off ramps, right? Because you need to get rid of some of the traffic. You can't accommodate all the traffic. Plea bargaining is an off ramp, right? Where you can pick off, right, a number of cases, get them out of the system, and you don't have to take them to trial, right? And the proper use of plea bargaining is a very important part of an efficient criminal court system.
So it's almost like an express lane as well.
Well, it is actually, it is, but it's more of an off-ramp, right? Because what happens in the plea bargain is the case is resolved.
Yeah, right.
Right, that car gets taken off the road altogether.
So there's no more traveling. Sir, I want to talk a little bit about a sexual offences court, something that is under consideration. Why would we need a sexual offences court, and how does this impact the administration of justice?
Sexual offences in a well-administered court system deserve special treatment because of the nature of the offence. The first thing is that best practices suggests that you really should try to dispose of sexual offences cases within a period of 12 months. Now that's a relatively short period of time for the disposal of a criminal case compared to everything else. The reason for that, of course, is the impact on the victim, all right, which is very traumatic. Witnesses, obviously, are affected. And the longer it takes a system to bring a sexual offences case to trial, the rate of conviction tends to decrease. Right? That's what the empirical data seems to suggest. So the takeaway of that is that you need to put some special emphasis on sexual offences cases in order to try and get rid of them within that period of time. Many times they involve minors, and of course that requires special treatment. The other reason why you might establish a specialty court is that the treatment of the victims has to be very different than the normal case. I think we all know this. It requires a far more sensitive and confidential awareness of the position of the victim, the virtual complainant. The witnesses themselves are oftentimes going through significant trauma. And so the whole way in which the court is set up, the way in which during court proceedings you have to protect the victim from coming into contact with the accused person, you have to have special arrangements to separate the different groups.
That must be very intimidating and traumatic.
Indeed.
Well, yeah.
I mean, this idea of a victim having to walk down sort of bike lane and may possibly come into contact with the accused or maybe with the family of the accused is really not acceptable. So we are thinking seriously about establishing a sexual offences court. Now, essentially, it's a criminal court, but it'll be a court which will have a special emphasis on sexual offence cases. We will try to target a 12 to 14-month disposition cycle. So those cases will have to be separated and targeted and managed, and that requires just some administrative support. And we would try to make what is a very difficult experience, the actual trial, a little more sensitive to the special needs of that type of offence.
I'm very heartened to hear that, because I think sometimes we look at, unfortunately, criminal matters probably with one view, and we sort of group them together. But in an instance like this, there are special circumstances that require.
You see, it is not one size fits all.
Yeah.
In a well-run modern court system, you do have to recognize that certain types of offenses require specialty courts, and that means also training. You have to train the staff. The judge has to be specialized in this as well. So it's not just a matter of opening a new building. You have to holistically plan and structure and manage that court in a way which is consistent with best practices in dealing with sexual offenses cases.
Along these same lines of specialty courts, I know that you are intending to bring some changes, or would like to bring some changes to the juvenile court system and how that is run. Talk to us about that, please.
Well, currently, the juvenile court is comprised of a presiding magistrate and a panel of persons who are drawn from persons appointed by the government. These are volunteers. They do a very important work. I must say, we've had difficulties in getting the panels together because many of these persons have other commitments. They are only able to give so much of their time to this process. Now, I want to make this very clear. The lay members of the juvenile panel are doing a great job for the country. It's national service. It's very important. The only difficulty is they have limitations because of their own time and their own commitments. So we are really only able to sit in the juvenile court maybe twice a week, and it's a short day. It's not a full court day because of these other commitments. So what we're looking at, and this has to be, of course, agreed to by the executive branch, because this would require amendments to the Child Care Act. But we're looking at whether or not we shouldn't just have a magistrate preside as opposed to a panel. And this magistrate would have access, of course, to social services, probation officers, and all of the necessary skill sets. Because I would like to see the juvenile court sit 5 days a week. I mean, the volume of cases and the backlog requires that, at least for a time. That's going to be very difficult to do with a panel. So, first of all, we're looking at some possible amendments to the Act, which allows the magistrate to sit alone. I mean, that could either be the position for all cases, or the actual accused person could have an option as to whether they'll be heard by a panel or by a magistrate alone. So we're trying to make that more efficient. Also, we need to have better support services from social services, the welfare department. In other words, many of these cases require non-custodial sentences. The facilities, the government facilities, have to have the capacity to absorb these people. We want to sit more frequently. We want to clear the backlog, and we need to put greater emphasis in the juvenile court because it's dealing with our young people, which of course is a very important resource.
And well needed and very timely. Sir, as we wrap up, I want you to really help us to understand what you would like your legacy to be. I mean, we're talking about legacy and you're just a year and some into sitting as the Chief Justice, but what is it? There are a lot of things that you have discussed today. There seems to be a very ambitious agenda. At the end of your tenure as Chief Justice, what would you want the public to remember the most about your time in this seat and the things that you would have attempted to do to the judicial system?
Well, I don't have time to think about legacies, but so let me respond as best I can. I think my greatest desire as a lawyer who has practiced for 41 years, I mean, I've been in the system a long time, my greatest desire would be to be recognized as introducing reform and modernization of our court system. My agenda in taking this office was to provide some national service. I'm a Bahamian, my family is all here, the Bahamas has been good to me, and I thought it was time to give something back. We need to modernize our court system. We have fallen behind. And my greatest emphasis has been to try and change the trajectory of the court system. It takes a while. It doesn't happen overnight. And given the mandatory retirement age that applies to the office of Chief Justice, I don't expect to be able to carry my agenda all the way to its conclusion. What I hope I can do is make a small contribution to changing the paradigm, altering the trajectory, introducing meaningful and sustainable reform and modernization, improve the service platform of the courts. I think it's very important. We need to render better service to the Bahamian public. And if I can accomplish any of that, and I can set in place a program of reform and modernization, then I would be very grateful, because really that's my highest priority at the moment.
Sir Brian Moree, thank you very much for taking this time to sit with us. This is the first time I've ever sat with a sitting Chief Justice, and so thank you. This is groundbreaking for us in many ways as well. And certainly you've laid out, as I said, an ambitious agenda. We wish you all the best. We see some of these things already happening. And I know that the public will be pleased to hear about some of the things that are happening and beginning to see them, because our court systems really for a long time have been a source of great anxiety to the Bahamian people. So thank you very much, sir. All the best to you, and we certainly will be watching and keeping track of what's happening.
Thank you, Mr. Swire. I appreciate the opportunity, and I regard part of my responsibility as Chief Justice is to be accountable to the Bahamian public, and programs such as yours allows me to do that.
And thank you very much. We do appreciate the opportunity. That's going to do it for this edition of On the Record. Very special thank you to my guest, the sitting Chief Justice, for agreeing to do this. Special thanks to the Balmoral Club for allowing us to use these accommodations. Thank you so very much. Also to my production and technical teams, thank you very much for putting this all together. On behalf of all of us, thanks for watching. We'll see you next time, same place, same channel, right here on The Record.